This week's question of the week is as follows. We are not the sort of people who look for lawsuits, but we really feel that the hotel my elderly mother stayed in for the holidays contributed to her getting hurt. They had just mopped the floor near the front desk, and she slipped and fell, breaking her left wrist. What do we need to do? Well, first of all, let's talk about premises liability law under the laws of the state of Tennessee. When you are injured on another person's property due to the negligence of the property owner or a person who is leasing the property from somebody, potentially you have a claim for injuries. To be able to recover from a property owner or a lessee, someone who's leasing the property, you would have to prove negligence on the part of that person that owned the property or that was leasing the property. There are three things that you have to prove, or rather one of three things that you have to prove to have a chance at recovering anything from a property owner. You have to prove, one, that the property owner created a dangerous condition, but yet they failed to warn about the condition, remove it, or repair the condition. Or you have to prove that the property owner or lessee had notice of that dangerous condition. For instance, let's just say the property owner didn't put the water on the floor in front of the front desk, but someone else spilled some water there and they had notice of that problem out there in the lobby. If you prove that you have to prove that they have notice of a dangerous condition and then they failed to post warnings or remove or repair that condition. Or the third thing that you can prove to establish negligence on the part of the property owner would be that if you could establish that a dangerous condition had been on the property for so long a period of time that in the exercise of reasonable prudence, the property owner should have known about this dangerous condition, yet they failed to remove it, repair it, or warn of that condition. So, again, to establish negligence on the part of a property owner, you have to prove that they created a dangerous condition, had notice of a dangerous condition, or should have known about the dangerous condition that caused your injury. Now, in the state of Tennessee, we have comparative fault. Your fault is going to be compared against the fault of the defendants in your potential claim. When I'm evaluating fall down cases or premises liability cases, I ask people whether there was any reason that they didn't see this condition. Your fault is going to be compared with the property owner's fault. It's very possible that a jury is going to think that you had just as much ability to see and avoid this dangerous condition in the lobby as the property owner had. So you need to look at this potential claim and look at what the potential plaintiff saw, what he or she could have done to avoid this, and then you have to also look at what the property owner knew and what they could have done to see or avoid this particular problem. If it appears that the property owner was more at fault and this was something that your mother shouldn't or wouldn't have seen had she been looking for it, then you probably have a decent personal injury claim. I have handled fall down cases, premises liability cases for over 25 years. I handle these type of cases on a contingency fee basis, meaning that I don't charge any money up front. Any attorney's fees that I would earn in the case are charged or as a percentage of the recovery, meaning I get a percentage of the recovery if I prevail. If I don't win the potential claim or get the case settled, then you would owe me nothing. I've handled premises liability cases for over 25 years with a good track record of success. I would be happy to help you if you or a family member have been injured on the property of another person. And as always, I'd be glad to help you get your life back.
Get your life back. Call the law offices of T. Verner Smith for a free consultation. 423-1888. 423-1888.